Welcome, everyone. We'll give it a moment for everyone to be able to enter the Zoom, and then we'll get started. So please sit tight. So we still have people entering the Zoom, so we'll give it a couple more moments before we get started. Thanks for your patience. Okay, well, I think now is a good time to get started. So, again, welcome everyone, and thank you for joining us today. My name is Mohsen Manesh, and I am a professor and the Associate Dean for Faculty, Research, and Programs here at the University of Oregon School of Law. And it's my great pleasure to welcome you to today's Oregon Law Perspectives webinar. The Oregon Law Perspectives webinar series brings the work of our distinguished faculty to our colleagues, our students, our alumni, and to the broader public. Today's session is the second in our summer series, and it will feature two renowned experts on treaty rights for Native American tribes, tribal sovereignty, and the law. First, we are thrilled to welcome Chuck Sams, who is the Oregon Tribes Scholar in Residence here at Oregon Law for the 2025-26 academic year, as well as the Senior Fellow with the UO's Native Environmental Sovereignty Project. Mr. Sams has more than 30 years of conservation experience working in tribal, state, and federal government and in the nonprofit natural resource and conservation management fields. He is also an enrolled member of the Confederated Tribes of the Umatilla Indian Reservation in Northeast Oregon, with blood ties to the Cocopah tribe and the Yankton Sioux of Fort Peck. Mr. Sams will share his insider's perspective on how federal agencies fulfill their trust responsibilities in the 21st century, including the roles of nonprofits in advocating for tribal rights and tribal governments. Mr. Sams will be followed by the incomparable Professor Howard Arnett, who is here for his sixth Oregon Law Perspectives webinar. Professor Arnett has practiced law for more than 40 years in Arizona and here in Oregon, representing tribal governments, tribal members, and Native American organizations. His practice in Bend has included work for tribes on treaty rights, tribal sovereignty, tribal law, development, government-to-government relations, water rights, and gaming. Professor Arnett will provide us with an update on a major case, Apache Stronghold versus United States, and explain what happened in the broad-based effort to save Oak Flat. He will also explore other developments involving Indigenous rights and religious freedoms. For more information on our scholar in residence, Chuck Sams, or Professor Howard Arnett, please visit the Oregon Law Perspectives website. Our plan for today's webinar is as follows. Our presenters will each speak for approximately 20 to 25 minutes and then take questions at the end of the hour. If you have a question, please feel free to use the Q&A feature at the bottom of your Zoom bar. Only the panelists and I will see your questions, and they can be anonymous if you so choose. We will get to as many of your questions as we can at the end of our presentation. For those of you who are seeking CLE credit, you will receive an email after today's webinar requesting your bar number so that we can report your attendance back to the Oregon State Bar. With those preliminary points out of the way, please join me in welcoming our speakers, starting first with our scholar in residence, Chuck Sams. Chuck, go ahead.
Thank you, Mohsen. It's such an honor to be with you all today. Tatshala and I'm you. And Good day, my friends and relatives. My Indian name is Mockingbird with Big Heart, and I spoke to you in the Sahaptin language of the Umatilla. It is wonderful to be here. It's wonderful to be with Howie. I'm a great admirer of Howie. He's been doing this since time immemorial, as they say, among Indian country. His work in Indian country is legendary, and his fight to ensure that our treaty rights are upheld has been very remarkable and very marked by everyone that I know who works in federal Indian law, including myself, in which I've learned from the cases that he's worked on behalf of my own people. So today, I'd like to start with you all. Let's see if I'll make this work. There we go. There. We're going to talk a little bit about advocating for tribal rights and fulfilling the federal obligations and how federal agencies are trying to fulfill those obligations in the 21st century. I spent the vast majority of my professional career actually on the outside work, looking in, mostly throwing rocks at the Department of Interior, trying to figure out to ensure that the United States government was fulfilling the Treaty of 1855, of which I am a member of under the Fort Walla Walla or under the Walla Walla Valley Treaties, the Confederated Tribes Umatilla Indian Reservation. And so I'm going to start talking mostly from the specific and my relationship to that treaty and how trust responsibility really is supposed to work for treaty tribes and for federally recognized tribes who were also formed under executive order. To understand the Columbia River Plateau and the Plateau tribes, one must understand that we come from a set of natural laws, or Tumunwit. And Tumunwit in the Sahaptin dialect means to originally be how we were stood up as human beings. We understand our laws that tell us that there was a time before humans, and that I myself was made and created from those that came before me. In other words, that my eyesight comes from eagle, my skin comes from hide, my hearing comes from owl, and that my entire nervous system and my blood system comes from the plant people. And the biggest gift and the single largest gift that we received was, of course, our voice from salmon, but more importantly, salmon's entire body. Waikanish Nui Thluma in our language means that we are keepers of the salmon. But beyond that, we are really keepers of the natural world. It means we have to be good stewards of those resources. And so for those of us who live in the Columbia Plateau, but I've seen this across Indian country, there is this full understanding of the natural law that we must be good stewards of these resources that help not only strengthen us as human beings and keep us alive, but help us thrive on this landscape. And it is these gifts of the land for the first people that were here that tell us that these covenants of stewardship are our primary responsibility. And so what you see in the negotiations all across Indian country, across the over currently over 300 plus treaties that still exist today, is a covenant that they have with their landscape, a covenant that they have with the air and the water and with the flora and the fauna. And how are they being met in order to fulfill those obligations with tribes all across the United States, and currently, which there are over 574. But tribal sovereignty as a whole, one first has to understand that tribes were sovereign way before the United States was here. Tribes were sovereign before the framing of the Constitution. As a matter of fact, there was a strong understanding by the European powers when they first came ashore here that tribes were sovereign. So much so that many of those foreign powers had already began negotiating with tribes in a whole number of ways through treaty making. And that treaty making happened, of course, up and down the eastern seaboard. But most importantly, the Constitution of the United States, when it was formed under Article 1, Section 8, addressed Indian tribes as follows: that Congress should have the power to regulate commerce with foreign nations and among them the several states and with Indian tribes. Of course, Article 6, Clause 2 of the Constitution, known as the Supremacy Clause, also establishes that U.S. treaties and laws made pursuant to the U.S. Constitution shall be the supreme law of the land. Indians are the only political group of people specifically mentioned in the U.S. Constitution, and the courts have affirmed the sovereignty of tribes, most notably in the series of the Marshall Trilogy, in the cases of Johnson versus McIntosh in 1823, Cherokee Nation versus Georgia in 1831, and Worcester versus Georgia in 1832. And the treaty commitments of the United States are of two kinds. In the language of Chief Justice Marshall in 1829, a treaty is, in its nature, a contract between two nations. It's not a legislative act. It does not generally affect, of itself, the object to be accomplished, especially so far as its operation in intra-territorial, but is carried into execution by the sovereign power of the respective parties to the instrument. And while the Chief Justice did say that we were dependent nations, it's still a far recognition that we have territorial rights and we have a right to govern ourselves, and that those negotiations that happen between our two parties are contractual obligations that each side must fulfill. Now, since that time period, though, Congress has enacted a whole host of laws. These are just a handful of over several hundred laws that Congress has acted since the forming of this great nation. And in those laws, though, tribes have to navigate on a daily basis of which of these laws actually apply to them and which do they not, because there's always a general act by Congress to make sure that trying to ensure that these laws actually apply to all tribes. but in many cases, they don't necessarily do because of those contractual obligations under those treaties. And so in some cases, some of these laws do apply, in some cases, they do not. And so when you are working with tribes as attorneys in Indian country, it's important that you have a very strong understanding of the treaty rights and or the federal obligations that have formed the treaty under executive order and how these laws may or may not affect the tribes individually. This is also a process that does tend to infuriate many of our partners that we work with, both at the local level, whether that's municipal, the county, with states, and even with our federal partners. Because, of course, federal agencies assume that every one of these laws apply to every tribe in the exact same way. And in my 30 plus years of experience in working across multiple federal agencies, that assumption always holds true. It's only when you start digging in and working with them on an individual basis and forming those relationships with federal officials, do we actually see that we are constantly spending our times as tribal representatives educating federal employees and state employees about how these acts either do or do not affect a tribe and to what extent they affect the tribe. And most importantly, what their obligations are in fulfilling those treaty obligations that they have with the United States has with tribes. For my own tribe, that was in 1855, the tribes had made an agreement with the United States government to cede 6.4 million acres of land, which is that the tribes gave the United States the land and reserved for themselves, they had believed, 500,000 acres. But due to a survey error in 1871, the tribes ended up only with a little less than 250,000 acres. And as of today, they only actually control about 172,000 acres within the state of Oregon, but they have, or within the reservation boundaries. They have an additional 5,000 acres that are beyond the boundaries of the reservation that they've acquired in the state of Oregon, and another 10,000 acres in the state of Washington. The importance of our treaty is pretty profound. Our tribe ensured that our tribal leaders, my ancestors, and my own grandfather, Pio Pio Mox Mox, who was the signer of the treaty on behalf of the Walla Walla people, ensured our reserved right to hunt, fish, and gather at all usual custom stations in the ceded lands that we gave the United States and those lands that we had been to, which means that we could go to Buffalo, and we had traveled to Buffalo in what is now Montana and Wyoming, that we could go down and we could gather fish all the way down into the Willamette Valley, which is in usufructuary right with other tribes, and be able to take those fish and then bring them back home. In addition, that we would be able to travel to those areas unmolested. It's also important to understand that the United States government and the treaty didn't give tribal any of these rights, that these were reserved rights that the tribes felt important in order of negotiating when they did grant these lands to the United States government. And tribes maintain a keen interest and involvement in the activities that occur in these areas, so much so that a number of court cases, especially in the 20th century, continued to ensure that tribes could co-manage a number of lands, access to those lands, and species off the reservation. And Howard Arnett has been very much at the forefront of those in the last 50 years with tribes here in the Pacific Northwest, and particularly the Warm Springs tribe. Now you can see from this map in our Aboriginal title that we gave up these 6.4 million acres that at the time was considered all of Oregon territory, but now of course spans the states of Washington and Oregon. And we have lands that we usual custom rights that go well beyond that, as I said, into what is present day Idaho, Montana, Wyoming, northern Utah, California, and southern Canada. Today, the tribes continue to practice their traditional rounds. They were seasonal people and not as nomadic as many people believe. And those traditional rounds are still practiced today in hunting, fishing, and gathering. My own family continues to fish down on the main stem of the Columbia at Cascade Locks, along into the major tributaries, both on the reservation and those that surround the reservation. We live with the land and continue to steward the resources as we had promised when we made our covenant with our Creator. We build and maintain a current modern government that was formed in 1949. This tribe just chose to not accept the 1934 Indian Reorganization Act. And in 1946, it hired its own attorney, a gentleman by the name of Charles Luce, who went on to become the head of Bonneville Power Administration in 1961. This attorney from Walla Walla, though, helped us fight a number of cases under the Indian Claims Commission Act, along with helped set up our modern tribal government. We also maintain now a modern economy. That economy provides a boost here in Northeast Oregon into the towns of Pendleton. Beyond traditional casino gaming that we do have, we also have a holding company that has bought 8A companies all across. And so we have also built out codes within the reservation that match many of the state codes on commercial and business use so that we can be able to ensure that businesses who do practice on the reservation can go into tribal court and know that their businesses are well protected and that they will receive a fair and understanding hearing before a tribal judge. And we develop community while holding on to our traditional structures while moving forward. But federal Indian law really dates itself back all the way to the basis of the doctrine of discovery, and understanding that this Christianity belief really had said that non-Christian people, upon immediately discovery by European powers, that the European powers had this dominance over them. And we see that play out in the Marshall Trilogy when you actually look at those three cases very closely. And yet, our federal Indian law canons of construction tell us that we must favor the decision as the Indian understands it and favor as the Indian understood because there's an understanding that early on that English, of course, was not the primary language of any of these natives across the United States, and therefore we must defer to them as they understood the written laws that they were putting to agreement to in these treaties, these negotiations, and these agreements. But in modern practice, we've seen over the last century, at least that there were courts had been deferring to tribes in that manner. In U.S. v. Winans in 1905, by example, the court fully understood the importance of fish to the Yakama Nation and to the tribes of the Columbia Plateau. That fish was just nearly as important as air was to their own breathing, as the court says. This was a case in which there were fish weirs and tribes were looking to gain access on private lands to fish at their usual custom stations, and that the tribes ended up having that right to cross those lands to regain to their usual custom stations so that they can take their fish. The Indian Reorganization Act of 1934, even though my tribe did not participate in it, was an act again to reaffirm the tribe's rights, both under treaty right and to ensure that tribes retain their rights to conduct their own business and their own affairs as sovereigns, whether they accepted the rebuilding of a modern community through cookie cutter constitutions that were provided by the Bureau of Indian Affairs, whether they continued to govern themselves under their own traditional manners, or whether they were decided to govern themselves in a way that was well defined but still approved by the secretary. Of course, in the 1950s, we did see a reversal for a small period of time. Public Law 280 reversed a lot of what the Indian Reorganization Act had put forward, and it gave a number of states, and eventually all the states across the country, the ability to have a criminal and civil jurisdiction over tribes. A number of tribes have led that fight in the modern era, especially over the last 25 years, to actually retrocede that power. In the state of Oregon, the Confederated Tribes Umatilla Indian Reservation have led that effort to retrocede a number of that power, especially in their work in the missing and murdered Indigenous women's. They've been able to retrocede the power so that they actually not only have jurisdictions in their courts over their own people for these criminal actions, but also over non-Indians who commit crimes on reservation. The Termination Acts of the 1950s, also Oregon was ground zero with over 40 tribes being terminated in the 1950s. The only tribes that actually survived termination initially were ourselves, along with Burns Paiute and the Warm Springs tribes. But many of the tribes along the coast were terminated and finally got restored in the late 1960s, 70s, and in the early 1980s. And then court cases that came about later around salmon in the particular area that you were most interested in looking at how tribes are able to push for that trust responsibility to protect their rights to those usual custom areas and to the fish are in So Happy versus Smith in 1969, which eventually becomes US v. Oregon, which has been the longest running court case in US history. Now it's been open for over 50 years, and which I know Howard Arnett has been a participant in for many of those years. And of course, the United States versus Washington in the Washington 74 and the Ninth Circuit in 75. Trust responsibility. In my time as a federal official, when I became director of the National Park Service, one of the things that I was most surprised about in visiting with many of my senior staff, but a staff all across, the National Park Service has 20,000 employees. And we all take an oath of office to uphold and defend the Constitution of the United States. And when I asked the staff, many of them to a T are very proud of the oath that they took and that they are a defender of the Constitution. What many of them didn't fully realize is though in upholding the Constitution that they had an obligation, as in the earlier slides, of upholding those treaties, upholding those executive order tribes' rights, that they are must fulfill their obligation and those trust obligations. It wasn't a full understanding that when they were doing so, that they must also build trust, personal trust between their relationships when tribes came to them. It's an understanding that as I dug deeper as a federal official, I realized wasn't being taught on a regular basis, not only within the Department of Interior, but all across our federal family. I'm very proud of the Biden-Harris administration and the secretaries of the different departments who were working hard in the previous administration to restart teaching that, and that there was an entire series of Indian law courses that were being offered throughout the federal system to ensure that there was a recognition that tribes weren't part of a DEIA movement, that tribes, as under the Constitution, were seen as a distinct political entity in which the United States must fulfill its obligations, and that they must develop reciprocal relationships with tribes so that tribes continue to work on and negotiating their water rights, that they had fish and wildlife protection, preservation enhancement opportunities, that there was not only just co-stewardship responsibilities, but there was actually co-management in public lands. And for the first time, we were working towards much more co-management based on those court cases that were on the previous slide. By example, the National Park Service, when I came on board, had less than a half a dozen co-stewardship, co-management agreements, and they only had four co-management agreements that were mandated through Congress by the setting up of those parks. And we worked very hard. By the time I left office, we ended up with 159 co-stewardship, co-management agreements across 433 units of the national park, and we had 50 that were pending. Since I left office, I'm happy to say that Secretary Burgum has actually approved seven more, according to staff. And so they're still being seen, of course, not as part of a DEIA movement, but actually fulfilling that trust responsibility and ensuring that not only is there a natural resource accountability and access for tribes, but there's also economic development and that there's also protection of cultural practices on these lands. Now, I'm not going to go through each and every one of these because I want to make sure that Howie has enough time and we can take your questions, but we're going to make sure this information is out to you, and I'm going to kind of hit the highlights of this. When working in Indian country, I get asked this a lot, what is best to do? These practices I set up about almost 25 years ago when people were talking to me. It's important that you listen first and foremost. A lot of times our own personal enthusiasms get in the way of the commitments that we're trying to make and we're in our country. Second, it's important that you learn about the people and the tribe that you're going to go work for or work with before you try to get anything done. So many times tribes spend so much more time educating the people who want to work with us that it actually delays our ability to work together and to actually get things done in a more timely manner. We must understand that each community or tribe has its own definitions of success. What may work for the Umatilla tribe may not always work for the Warm Springs tribes or for the Yakama Nation, even though we have a common language base as Sahaptin and that we have a common cultural practices in many of these tribes, we actually have different ways of defining success for ourselves. Respect is earned every day in Indian country, and relationships are built on points of agreement. And we constantly should make lists and document where you agree, but also document where you don't agree and to come back to those disagreements to find out where those common grounds are that still can be met. Always be direct, be straight, and tell the truth. Tribes have dealt with over 200 years of someone trying to sell us goods that we don't want, and we know that we are seeking and recognize that the whatever it is subject to negotiations, and that those rights that haven't specifically been negotiated in treaties are still negotiable to this day with federal agencies and institutions. We want to solve problems together and to find ways to do it together and accept that all will arrive and the biases and that may not be helping our problem solving. Understanding that tribes have their own set of laws and that tribes have set up a very complex set of laws that both mirror federal and state law, but also have part of those laws that I talked about in their natural laws and upbringing, and that they've started to codify some of those laws. So when you go in to work with tribes, is looking up and looking at their own codes and their own laws and structures and having a better understanding of what those are, because you won't necessarily find those in your law books that you have in the institutions at the University of Oregon Law or many other institutions. You actually have to go seek those out with individual tribes. Always remember that you're a guest in the tribe, in a tribal community. We always serve our elders first, and they are the heart of the community. I've learned if you've ever want to make radical change on a reservation, you go to the elders. In the Western society, you go to youth to make radical change. If you really want to make radical change, you talk to the elders. And I know that when we've had good attorneys serving in Indian country, their relationships with the elders is what has really helped develop our best avenue of fighting for our rights and ensuring where we want to go into our future. Understanding that turnover, cultures that have the stability for thousands of years are recovering for a couple hundred years of cleric and federal subsidized attacks. So we're looking for stability. We have a sense of humor and always know that, as Howie's probably been exposed to, if we're not teasing you, you should be worried. Teasing is a form of actual somebody liking you in our country, in Indian country. But having a sense of humor and being able to laugh at yourself and knowing that we will make mistakes along the way, we can do it together. But in those mistakes, we can learn a lot of important lessons. And we continue to thank people and organizations. Some cultures believe that you should give thanks 7 times, in doing so to help focus on the good that we repeatedly do. Because in our country, we believe that you're going to do good. We believe that you're a good person and that we know that you're good. Understanding that trust responsibility in the federal agencies is a continued learning opportunity. What we've seen in the current administration is this loss of institutional knowledge. And there are people, though, that I believe this is an opportunity for those of us who work in legal realm to continue to push for trust responsibility. What I've seen is this younger generation, and those are the ones that are currently who are still in federal service, really want to understand and fulfill their obligations under trust responsibility. They want to learn what that is. They want to ensure that they are meeting that obligation and fulfilling treaty rights and rights that tribes have under executive order. And this is a great opportunity that I see as the only silver lining sometimes in this administration. But for those of us in the legal profession, we have a wonderful opportunity to continue to educate so that we can work on behalf of our clients in Indian country to ensure that their treaty rights are being protected. So thank you all. I appreciate your time.
Excellent. Thank you, Chuck. And as I said at the outset, if you have questions, feel free to use the Q&A feature at the bottom of your Zoom bar. We'll get to them after our next presenter. With that, let me turn it over to Professor Howie Arnett.
Thank you, Mohsen. And hello, everybody. And thank you, Chuck, for the glowing words about me. I'm bashful of thinking about that. But anyway, thanks so much. Well, the actual discussion we're going to have in my little piece of this presentation is going to be slightly different than I thought it was going to be maybe 6 weeks ago. This webinar we did last summer was about the Apache Stronghold versus United States case, which had been decided by a sharply divided en banc panel of the Ninth Circuit against the tribal interests in May. And we were certain it was headed to the Supreme Court. And so we anticipated that it would be heard by the Supreme Court, or there would be some sort of an outcome in the Supreme Court in this last term of the Apache Stronghold case. And we would know what that outcome is. Actually, it's still in doubt, almost unbelievably. It's still in the Supreme Court. It's hanging by a very thin thread, as I'll explain, but it's still there. So I'm going to go to screen share and talk about Apache Stronghold in the Supreme Court, and also the associated litigation in the lower courts. There are now 3 other cases in the district courts. 2 in Arizona, 1 in DC, and the 1 in DC just got sent to Arizona this last week. And so we'll talk about that. So I'm going to screen share first to, let's see here. Hopefully this works. Yeah, there we are. So what I'm going to do is talk about Apache Stronghold, an update, what's going on. And as I called it last year, I consider it the most consequential Native American religious freedom case in 3 decades in this country. And we'll have an update on the other Oak Flat sacred sites litigation. And so we'll sort of talk about Apache Stronghold. We'll talk about the lower court cases, where they are. There was a 5-hour preliminary injunction hearing, and 2 of them in Arizona District Court on Wednesday, 2 days ago. But for those of you who don't even know what Oak Flat is, or where it is, or what a sacred site is, and how the legal principles at play, I'll lay some background. If you watched this seminar last year, you've already heard this, but so I'll try not to spend too much time on it. So this is Oak Flat. It's a Apache sacred site for the Western Apache people, who currently are on 4 different reservations in Arizona. Closest is San Carlos Apache. And it's part of a national forest. It's 6.7 square miles of the Tonto National Forest, is east of Phoenix. It's a well-recognized sacred site for the Apache people. It's on the National Register of Historic Places, considered a historic district for the and cultural property for the Western Apache people. What happens at Oak Flat is Apache ceremonies. And in the Apache religion, it's the only place in the world where these religious rites can take place. The most well-known of those is called the sunrise ceremony. It's a 3-day coming of age ceremony for young Apache women. And there's a fairly elaborate discussion of it in Justice Gorsuch's stinging defense or dissent from the denial of cert last May, which is now being considered for reconsideration by the Supreme Court. And he talks about the sunrise ceremony. And interestingly, there was a late in the term Supreme Court decision called Mammut versus Taylor, which is also a free exercise case. It's not a Native American case at all, but it seemed to clarify and perhaps not expand, but give a different take on the meaning of substantial burden under First Amendment of the Constitution and under the Religious Freedom Restoration Act. And it involved parents of children. And the Supreme Court recognized they have a right that's protected by the Constitution to control the religious upbringing of their children. Based on that ruling, there was another lawsuit filed by Apache women and the mothers and their daughters, basically based on that new Supreme Court decision, using that as a cause of action in the Supreme Court, and to basically save the sunrise ceremony. So this is the legal background. This is Oak Flat. It's a 2,422 acre parcel, Tonto National Forest. Congress passed a statute in 2014 under sort of shaky circumstances. It had been pending in Congress for a long time, and they couldn't get the votes to pass it. It requires that the Forest Service convey this Forest Service land, Oak Flat, to a copper company, Resolution Copper, and in exchange for other property, supposedly of equal value, in Arizona, owned by the copper company. And this statute, the Land Exchange Act, is really the centerpiece of the litigation and the dispute. It requires the Forest Service, but also requires the Forest Service not only to convey the land, but do that after they've completed the NEPA process. And this statute was passed by Congress at the very end of a Congress when the Defense Appropriations Bill was pending before Congress. That's must-pass legislation. This was tacked on to it as a rider. Some called it a midnight rider, but it became law. So the fight has continued since then to fight the execution of the Land Transfer Act. And if it goes through, and if the copper company acquires the property, they build a mine. An open pit copper mine will eventually develop on the property, the Oak Flat property, where the Apache cultural resources and sacred ceremonies take place. This is what an open pit copper mine looks like. Southeastern Arizona has been known for years and have large copper deposits. There are mining towns in Southeast Arizona. Superior is the closest one to Oak Flat, Miami, Globe, and others. And this is one at Morenci, Arizona, what an open pit copper mine looks like. They're big and they obliterate the landscape. The proposed mine at Oak Flat for Resolution Copper, eventually the crater would be 2 miles wide and 1,000 feet deep. And so obviously there's no more sunrise ceremony or any other Apache ceremonies would take place there. So Apache Stronghold's claims, they're basically suing and saying, number one, the Land Exchange Act requires its conveyance from the Forest Service to the Copper Company is unlawful. Number one, it violates the First Amendment's free exercise clause, the right to protect a person's free exercise of religion. And second, it violates a statute, the 1993 Religious Freedom Restoration Act, which more or less kind of embodies in statutory form the elements of a constitutional claim under the free exercise clause. For both of these causes of action, both these claims, a central disputed legal issue common to both of them is whether the impact of the Land Exchange Act, which, as I said, eventually results in the destruction of Oak Flat as a sacred site, imposes a quote unquote substantial burden on the free exercise of religion. So a quick summary for those of you who left law school some time ago and may not remember your con law, the First Amendment free exercise analysis under the amendment is a two-step analysis, two-step analytical framework. Step number one, plaintiffs have to show that the government action substantially burdens their free exercise. If they can't do that, they're done. If they can do it, then step two is the burden shifts to the government. The government has to justify the substantial burden, and they have to do it by a compelling interest. If the interest isn't compelling enough, the claim succeeds. If the compelling interest is good enough, then the claim fails. The key authorities in this area you hear a lot about in this litigation, in this whole Apache controversy, Oak Flat controversy. Wisconsin versus Yoder, a case of Amish parents were criminally prosecuted for withdrawing their kids before the age of 16 from school, violates Wisconsin's criminal laws. And that was upheld. That was held to be a substantial burden on their religious beliefs, and the government could not provide a compelling interest. And the key was that there was a criminal prohibition involved. Parents could go to jail for just practicing their religion, taking their kids out of school. So the claim was upheld. The second one that described an actionable claim was a Seventh-day Adventist case, Sherbert versus Werner, involving a practitioner who refused to work on Saturday and was fired, and then applied for unemployment benefits, and the unemployment benefits were denied. Her claim was that's a violation of her First Amendment free exercise right. Supreme Court agreed, said essentially she's being penalized, can't get this benefit, and essentially being coerced to get those benefits by violating the tenets of her religion. So those are two solid descriptions of what a substantial burden is that's actionable in a free exercise case under the First Amendment. There was another case where the Supreme Court rejected the claim, involved Social Security numbers. Parents said their child were told they had to get a Social Security number to get certain benefits. And they said, that's against our religion to give our child a Social Security number. And the Supreme Court said, that's just your subjective religious belief. There's no coercion, there's no penalty, there's no claim. Then there was another case. This was the most recent one. In late June of this year, Supreme Court decided this Mahmood versus Taylor case. I just alluded to that. This is a mandatory public school curriculum materials were objected to by parents of various faiths. It was a coalition of Catholics, Orthodox, Muslims, various other religious traditions held by the parents. Say, we don't want our kids exposed to this material that's directly contrary to the way we want to raise our kids, in particular, the way we want to teach them proper religious beliefs. Supreme Court agreed, said that's a substantial burden, and the claim was upheld. So that's the latest sort of case law on the First Amendment. So the free exercise claims in a Native American context under the First Amendment, the big one is the Ling case from Supreme Court 1988 involving religious practitioners on national forest land, Six Rivers National Forest in distant Northern California, not far from the Oregon border. Forest Service approved a road construction and a timber sale in this area, this High Rocks area of the national forest, where the tribes in that area conducted religious ceremonies. They said our religious ceremonies require total solitude and quiet. And if you're going to have a timber sale, if you're going to have roads and log trucks drive by, it's going to destroy that quality, which is just essential to our religious traditions and practices. Supreme Court said, nope, that's just your subjective beliefs. So there's no objective penalty, there's no objective coercion. And interestingly, Chief Justice or the Justice O'Connell wrote the opinion, said, by the way, this is government land, and the government has broad constitutional latitude regarding the disposition of its own land. It's public land, it's everybody's land. And so essentially, she carved out an exception to the substantial burden requirement in the context of government use of government land. The Supreme Court holding there was utilized by the Ninth Circuit in Navajo Nation versus U.S. Forest Service, which involved a ski area, Arizona Snow Bowl, just north of Flagstaff, that wanted a permit to use, make artificial snow to lengthen the season, but the artificial snow would use water that's essentially treated sewage. And the tribes in the area objected and said, that offends us. You're putting basically poop on our sacred site. And that's not allowed. That offends us. Supreme Court said, that's just your subjective belief. Plus, this is government land, and the government's got wide constitutional authority what to do with its own land. And the next case was Apache Stronghold in the Ninth Circuit that we'll talk about in just a second. So there's a second cause of action under the Religious Freedom Restoration Act, or RFRA. That statute was passed by Congress because of another Supreme Court case in an Indian law case, but nothing to do with sacred sites. It was the use of peyote by practitioners of the Native American Church. It's the sacrament. It's also a controlled substance. Possession and use is criminally prohibited. And Supreme Court sort of stunned everybody by saying, you don't even do the substantial burden, compelling interest, two-step analysis. If it's a generally applicable, non-discriminatory criminal statute that isn't targeted at the religion or the practitioners, then you're not even in the First Amendment. Essentially, you don't do the analysis, the Yoder-Sherbert two-step analysis. There's no claim, and there's no constitutional violation. And so the statute was passed. Broad range of religious groups objected to that. Congress passed a statute that essentially brought back the two-step Sherbert-Yoder framework for analysis and said that any government action that substantially burdens free exercise, it violates First Amendment unless it's offset by a compelling government interest. Plus, this isn't in the case law, pre-Smith's case law, it adds that it has to be the least restrictive government action possible. So the two key legal issues under RFRA that have been fought over by courts since then, including right now in the Apache case in the Supreme Court, is the meaning of substantial burden under RFRA expanded beyond the pre-Smith First Amendment case law, Sherbert and Yoder? If it is, how far does it go? I mean, what else does it cover? Mammut seems to say it does go beyond the Sherbert-Yoder classification of coercion and penalties. The second question is there an implied exception to the substantial burden requirement in cases involving government disposition of government real property? That's another issue being fought over in terms of what the Religious Freedom Restoration Act actually did. Apache Stronghold in the Ninth Circuit, we talked about this a year ago, long opinion, 7 opinions actually, 6-5 narrow, fractured en banc ruling. They had 2 short per curiam opinions, first holding by 6-5 majority that part of the Navajo Nation case, the ski area sewage case, was actually being overruled to the extent that Navajo Nation implied you had to have a claim that looked just like Yoder, just like Sherbert, with a penalty or coercion. And they said, no, it's really broader than that. And actually preventing access to a religious site and preventing access to a place where you need to be able to exercise your religion, that does constitute a substantial burden. But they then went on to say, this case involving Apache Stronghold in the conveyance to Resolution Copper and destroying Oak Flat, that doesn't violate RFRA because it involves the government's disposition of its own property. They supported Justice O'Connor's laying distinction between use of government land, expanding essentially the constitutional freedom allowed the government to dispose of its own property. And they said essentially it's an implied exception in RFRA. So key issues that went to SCOTUS was what's a substantial burden for purposes of First Amendment and RFRA, and does a substantial burden change? Does that analysis, does that inquiry change in the context of government disposition of government land? So the cases we just talked about, Sherbert, Yoder, Ling, new one, Muhammad, and Navajo Nation, Apache Stronghold, those are all the relevant authorities. So now we're in the Supreme Court. This is the Apache Stronghold journey through the Supreme Court. Started with cert petitions last September. It followed 15 amicus briefs, all supporting the Apache Stronghold cert position, and usual expectation of religious freedom and tribal groups. Plus, there was a 4-state amicus brief, Oklahoma, Mississippi, South Carolina, and Oregon. Interesting alignment of red and blue states joined that brief. And there was even a brief from very conservative Utah Senator Mike Lee supporting Apache Stronghold, asking the Supreme Court to take the case. Respondents filed their briefs, the United States and Resolution Copper, no amicus briefs on their side. So then the Supreme Court held conferences, as they do when they're ready to consider a cert petition, 15 conferences. Those who following this were kind of looking every time they knew when a conference was, you looked the next Monday to see what happened. No decision, no decision, no decision. 15, I don't think is a record, but it's a lot. It's an unusually large number of conferences. Finally, the end of May, petition denied. And Justice Gorsuch, in a stinging, blistering dissent, was joined by Justice Thomas, surprisingly, and Justice Alito recused himself for unknown reasons. And so that was the outcome. So then Apache Stronghold filed a petition for rehearing because they said there's other case working its way through the Supreme Court this term, this Mahmoud case, excuse me. And Mahmoud case working its way through the Supreme Court, and decision hasn't been rendered yet, but we think if the petitioners win, that's going to maybe be intervening authority supporting us, and that would justify what I'll explain just below is what's called a GVR. They asked the Supreme Court to grant the rehearing, to vacate the cert denial, and remand back to the Ninth Circuit in light of this intervening authority in Mahmoud. And when the Mahmoud was decided at the end of June, it definitely talked about what is a substantial burden. And I'll talk a little bit more about Mahmoud in a minute. So the rehearing petition was distributed to the conference, and the next conference is August 15th. And probably if they make a decision, it'll be announced the following Monday, that's August 18th. And their options are deny the petition for rehearing, which is the most often the outcome in these things, or they might order a GVR, grant, vacate, and remand to the Ninth Circuit, takes it off their docket and see what the Ninth Circuit does in light of Mahmoud. Order request for additional briefing from the respondents. The respondents haven't weighed in yet, and they're not allowed to unless the Supreme Court wants to hear. So something like that will come out most likely on the 18th. Mahmoud is interesting. I said it was parents held these strong religious views regarding sexuality and gender. The school district, Montgomery County School District, northern and western suburbs of Washington, D.C., large school district, they had for young kids, kindergarten for 5th grade, I think, these LGBTQ inclusive storybooks. And there was no parental opt-out and no parental notice. That was a problem for the school district. And the school district's action was held to be a substantial burden on the parents' faith-based beliefs and teachings of their children. The court said they had long recognized that parents have a right to direct the religious upbringing of their children. That's a right protected by the First Amendment. And interestingly, the plaintiffs in the Mahmoud case were the same, not exactly the same lawyers, the same law firm, the Beckett Fund for Religious Liberty, as represents the Apache Stronghold plaintiffs. So Justice Gorsuch's stinging defense he writes some interesting stuff. The first thing he says is this case meets all of the standards we generally apply when assessing petitions for seeking our review. Ninth Circuit decision, he said, was highly doubtful as a matter of law, and it's an outlier. It's at odds with the other federal circuits, including the 10th Circuit, where he came from. And so essentially, there's a circuit conflict, which is usually a good basis for Supreme Court review. But it didn't work so far. And then on the government's claim that there was a government lands exception in the based on RFRA, and he said this is a RFRA in the statute. Exactly nothing in the phrase substantial burden or anything else in RFRA's text hints at a more and different demanding standard applied when and only when the disposition of government's property as at issue. So he tossed that away. And then he said, in conclusion, just imagine if the government sought to demolish a historic cathedral on so questionable a chain of legal reasoning as the Ninth Circuit's decision. I have no doubt we would find the case worthy of our time. And he called it a grievous mistake not to hear it. So in sum, I want to just quickly touch on this. These are the two cases, San Carlos Apache Tribe versus U.S. Forest Service and environmental groups versus U.S. Forest Service. These are the cases pending in Arizona District Court, raising a variety of claims, a lot of them NEPA, environmental permitting type claims, but also the tribe raises some treaty claims under the 1852 Treaty with the United States and the 1848 Treaty of Guadalupe Hidalgo with Mexico, some other statutes. Environmental groups focus specifically on the equal value appraisals that are part of the Land Conveyance and Land Transfer Act, that the value of the land that is being swapped for Oak Flat has to be roughly equal. And this was really the major focus of this 5-hour hearing in district court on Wednesday. The DC case was 4 Apache women and their daughters basically taking a moot cause of action based on that decision in late June in the Supreme Court and said, we're just like those parents, same thing. This is a substantial burden by destroying the sacred site, only place the sunrise ceremony can occur in the world. We're just like the parents. That's government action substantially burden our First Amendment freedom. That's now in the Arizona District Court. Same judge as the 2 other cases. No,
Howie,
yeah.
Let's pause there just so we can have time for some questions, and
Sure.
we have some questions coming in through the chat, and a couple of them are related to what you were just talking about here. So I'll direct these to you, Howie. One question is about, and I had a similar question, is to what degree do the federal courts, when they are adjudicating religious freedom cases, treat religious freedom cases involving Native tribes any differently than religious freedom cases not involving Native tribes? And should there be a different test that might be applied that recognizes or accounts for tribal sovereignty when it comes to religious freedom in Native rights?
Yes, they tend to be treated differently. One important point is that most of these sacred sites are on public land that are either Forest Service or BLM or national park land. And they have mostly failed. So the First Amendment and RFRA have not protected those religious practices as relate to the sacred and Native American sacred sites and practicing on these public lands, and partly because they are public lands. That seems to be treating things differently. So, and arguably, as your question poses, there should not be a different standard, but it should be higher. It should be a more protective standard for Native American practitioners on these public lands and elsewhere. That peyote case, the Smith case, actually, that's now legalized for across the country for Native American bona fide practitioners of the Native American Church. So yes, it is cheater definitely, and it's worse, but it should be better.
Another question, and I think this one is again for Howie. Does the Religious Land Use and Institutionalized Persons Act intersect at all with the sacred site cases?
Yes, that was a statute passed by Congress after the Supreme Court held that RFRA did not apply to the states. Congress passed another statute, said, well, it does apply to the states if it's about institutionalized people or land use decisions. And the analysis has been held to be about the same. Justice Gorsuch and others have pointed out that that illuminates Congress's intent in the Religious Freedom Restoration Act. It did intend to create a different definition, a broader definition of what constitutes a substantial burden.
Thank you. Here's a question for you, Chuck. Could you please share a little bit more about the lessons you've learned through your work with shared stewardship or co-stewardship agreements with tribal nations?
Yes, in doing so, each of those have to be really tailored to those tribes, and especially some of them which are a collection of tribes, and having to ensure that you're meeting those rights on their treaty obligations. They're not something that can just be done overnight. We've talked about tribes of ensuring that there's a reciprocal relationship and an understanding, and that they're met as equals, and that the staff need to go to the reservation rather than have them come to the national park, by example, or to the forest. And so that those negotiations you begin at the tribal sovereign's facility, and then working through those issues about co-stewardship and co-management and what are the legal principles that underpin them, usually going back either to the foundational documents of both the treaty and the foundational documents of what was that park site originally set up for. Because parks are usually either set up for cultural purposes or natural resource purposes. Then, so what are we protecting and preserving under that co-stewardship agreement or co-management agreement? That being said, inside of about 3.5 years, we were still successful in finishing 159 of them. That also shows what I thought of the aggressiveness of young staff, and staff really wanting to work with tribes. And of course, tribes have been waiting for years for these opportunities to be able to get access back onto these public lands so that they can continue on with their obligations that they've had since time immemorial, to protect and preserve these sites. But the complexities, are great and they're strong. But I think that that's what forms those stronger bonds and relationships between federal agencies and tribal governments.
Thank you. Another question about Apache Stronghold. How you mentioned at the outset that this case is one of the most consequential Native American sacred sites cases in 3 decades. Can you elaborate on why you think that is, and what makes this case so different than others that have come in the last 3 decades? And then Chuck, I wonder if you share in that assessment. So Howie, why don't you go first?
Well, because if Apache Stronghold, the facts of the case, the destruction of this bona fide, everyone agrees, totally sacred site, only place in the world that the Apache religion can be practiced, if this doesn't constitute a constitutional claim or a RFRA claim, religious freedom restoration, then nothing does. If it involves a Native American practice, it's on a land, public land, it's just not going to work. That's why it's consequential.
I see. And Chuck, do you have the same sentiment about this case?
I do. I've been following it, and I concur with Howie's assessment on this. And I look across. If the First Amendment doesn't apply or referendum doesn't apply, then what's the point? We're supposed to be protecting everyone's religious freedom and everyone's religious rights. In this particular case, they've been here since time immemorial. This is an old religion.
Thank you. Well, I think we have time for one more. A question about whether either of you can speak to the degree to which these pending cases are subject to being mooted via statutory amendments, and to the degree to which cases that bring claims based on statutory claims are more vulnerable than ones that are based on constitutional claims, because statutes can be so easily amended and can be easily amended when we have unified government like we have now.
Well, that's a risk. RFRA is a statute too. And
That's right.
so it, by the way, I still have this last slide, and I have a link to an Arizona Republic Online article that appeared yesterday that explained what happened in the 5-hour hearing in Phoenix on Wednesday. August 19th is the drop dead date. And that's the date where under the statute, the transfer has to be made. It's also subject to an existing injunction that expires on August 19th. One of the issues in the hearing Wednesday was whether the judge that's a mandatory under the statute. Congress told the Forest Service this conveyance has to be made, and the government's lawyers and the copper company's lawyers told Judge Lanza, yeah, this is not reviewable. You really can't do anything. You can't extend that. I don't think he particularly liked that, according to the Arizona Republic, but that is the drop dead date, unless the judge extends it or something else happens. So.
Thank you. Unfortunately, we could go on and we have more questions in the chat, but we're at time. So let me thank you, Howie, Professor Howie Arnett, and to our scholar in residence, Chuck Sams, for leading us today in a fascinating discussion. And thank you to everyone out there for tuning in. We hope you will join us for our third and final webinar of our summer series. Next Thursday, August 14th, Professor Angela Day will discuss her research in a talk entitled Racialized Burdens and the Power of Rulemaking, Unraveling Discriminatory Liquor License Enforcement. That talk is eligible for Oregon Access to Justice CLE credits, so we hope that you will join us next Thursday for that webinar. In the meantime, thank you so much again for joining us. I hope you have a great afternoon and weekend.
Thanks, everybody.